Hello friends, as part of my video lecture series, today I would like to explain the law of registration as under Transfer of Property Act 1882 and Registration Act 1908. The provisions pertaining to registration of instruments are specified under two important legislations in India. They are the Transfer of Property Act 1882 and Registration Act 1908. The people have some ambiguity with regard to these two terms, the registration fee and stamp duty, but these two terms are entirely different from each other. The registration fee is the fee charged by the government in order to keep a document in public records. The provisions related to registration fee are specified under Registration Act, but the stamp duty is levied by the government to raise the revenue and to recognize a right. The provisions related to stamp duty are specified under Indian Stamps Act 1899. Here, the person, simply the executor, who is executing a particular instrument, needs to register such instrument as per the provisions of Registration Act. If the registration is compulsory, he should register such document in the concerned registering officer or in the concerned registering officers with due process. But whereas the stamp duty is a kind of tax levied by the government in order to raise the revenue, and it recognizes the right of a particular person. If an instrument is not sufficiently stamped, then the courts and tribunals cannot accept such instrument as the evidence. Sufficiently stamped instruments are always recognized as the evidences. An instrument which is registered as per Registration Act 1908, then such instrument is to be kept as a document in public records in registering offices. This is the difference between registration fee and stamp duty. Registration fee is charged by the government to keep a document in public records. The registration fee is, the provisions related to registration fee are specified under the Registration Act 1908, whereas the stamp duty is levied by the government in order to raise the revenue and it recognizes a particular right. Insufficiently stamped instrument cannot be treated as an evidence in the court of law. The provisions related to stamp duty are specified under Indian Stamps Act 1899. Now, the law of registration in India is explained under the Transfer of Property Act 1882 and the Registration Act 1908. Coming to the Transfer of Property Act, Section 54, 59, 107, 118 and 123 of Transfer of Property Act are related to registration of instruments. As per Section 54, registration is compulsory for the sale of immovable property of the value 100 rupees or upwards. Sale is the transfer of ownership from one person to another person. Whenever the immovable property is sold by one person to another person, here the person who sells the immovable property is known as seller, and the person who receives the immovable property for a price is known as the buyer. If the value of such immovable property is 100 rupees or more than 100 rupees, for such transaction registration is compulsory. The instrument of sale of immovable property of value 100 rupees or more than 100 rupees, the registration is compulsory as per Section 54 of TPA. Coming to Section 59, according to Section 59 of Transfer of Property Act 1882, registration is compulsory for the mortgage of the property of value 100 rupees or upwards. Mortgage is a kind of transfer where The rate of interest is transferred from the mortgager to mortgagee as a collateral security. Here, the instrument which is pertaining to mortgage of certain property and the value of such property is 100 rupees or more than 100 rupees, then for such transaction registration is compulsory as per section 59. The next provision under Transfer of Property Act related to registration is section 107. According to section 107, registration is compulsory for the lease for year to year or leases for more than 1 year and the leases reserving a yearly rent. Lease for year to year registration is compulsory. Lease for more than 1 year registration is compulsory. Lease reserving a yearly rent registration is compulsory as per section 107 of Transfer of Property Act. As per section 105 of Transfer of Property Act, lease is the transfer of right of enjoyment. The right of enjoyment over certain immovable property is transferred from the lessor to the lessee for an infinite period or a particular period. If such period is 1 year or more than 1 year, then the registration is compulsory as per section 107 of Transfer of Property Act. But in Andhra Pradesh, as per the amendment made to the Registration Act, leases for any period, even for 3 months or 4 months, registration is compulsory. Next, section 118 of Transfer of Property Act. Registration is compulsory for exchange of immovable property of value 100 rupees or upwards. Exchange is a kind of transfer where one party gives some property to another party and another party gives some other movable or immovable property to the first party. In exchange, simply the transaction of barter take place between the two parties. Such exchange may be take place between the two parties with relation to movable and movable property or immovable and immovable property or movable and immovable property. Here, the exchange of immovable property. If the value of immovable property in such exchange is 100 rupees or more than 100 rupees, then for such transaction, registration is compulsory as per section 118 of Transfer of Property Act. Next, the last provision is section 123 of Transfer of Property Act. As per section 123 of Transfer of Property Act 1882, registration is compulsory for the gift of immovable property irrespective of its value. Gift is transfer of certain movable or immovable property by the donor to the donee without consideration, and such transfer should be voluntary transfer and the donee should accept the offer given by the donor during his lifetime. These are the essentials of the gift. For more details related to the law of gifts, just watch my previous video on YouTube with the title Law of Gifts as under Transfer of Property Act 1882. Here, the gift of immovable property irrespective of its value, registration is compulsory. These are the important provisions in Transfer of Property Act with relation to registration. Under the Registration Act 1908. The Registration Act 1908 extends to the whole of India except the state of Jammu and Kashmir. The Registration Act is applicable to the whole India but not the state of Jammu and Kashmir. The state government may exclude any districts or tracts of the country from, not from, sorry, M is missed. The state government may exclude any districts or tracts, any districts or sub-districts of the country from its operation. It is specified under Section 1, subsection 2 of Registration Act 1908. The Act came into force from 1st January 1999. The objective of the Registration Act is to consolidate the enactment related to registration of documents. Next, the overview of Registration Act 1908. Once we understand the overview of Registration Act 1908, we can easily understand the rest of the concepts. One should keep the entire view of the Registration Act in his mind so that he can easily understand, he can easily relate, he can easily interrelate one concept with another concept. Here, broadly speaking, there are three important parts in the Registration Act 1908. This kind of three parts are divided by me for lucid understanding. The first part is related to registration establishment. The second part is related to registration of documents. The third part is related to other important provisions in Registration Act 1908. The first part, that is registration establishment, speaks about certain establishment as under Registration Act. The persons appointed by the state to looking after all these actions related to registration. The Inspector General of Registration, Inspectors of Registration, Registrars of Registration, Sub-Registrars of Registration, they are the important personnel. Sorry, they are this is the hierarchy under Registration Act. This is the registration establishment. In the further slides, I will explain in detail about the registration establishment. The second part is registration of documents. For better understanding, I have enumerated various points under registration of documents. Irrespective of the series of sections, I have arranged these points under registration of documents. The first one is the documents of which registration is compulsory. Here, these are the sections deal with compulsory registration of documents. The registration of documents of which registration is not necessary. Registration of documents of which registration is optional. The documents exempted from registration. Procedure for registration. The time and place of registration. Effect of non-registration. These are enumerated under part 2 of this video lecture. The registration and deposit of wills. Reasons for refusal of registration. Appeals and applications. Fee for registration, searches and copies, and penalties is specified under other important provisions. But the fee for registration, searches and copies, this part is specified under sections 78 to 80. I have not prepared any slides in this video regarding the fee for registration, searches and copies. Why? Because the state government makes the rules related to fee for registration, searches and copies. Hence, it is better to refer the appropriate state government's rules related to fees for registration, searches and copies. It is specified from section 78 to 80. Let us discuss the first part, that is registration establishment. This is Inspector General of Registration, Inspectors of Registration, Registrars, Sub-Registrars. Here, the state government shall appoint the registration establishment in their state. In the hierarchy of registration establishment, it lies in the top position. The Inspector General of Registration stands in the highest level in the hierarchy, followed by Inspectors of Registration, Registrars and Sub-Registrars. The state government shall appoint all Inspector General of Registration, Inspectors of Registration, Registrars and Sub-Registrars. The provisions related to appointment of Inspector General of Registration is specified under section 3. Appointment of Inspectors of Registration is specified under section 8. The appointment of Registrars and Sub-Registrars is specified under section 6 and 7 of the Recession Act 1908. The state government shall establish a registrar office in every district, a sub-registrar office in every sub-district. The state government divides the entire state into certain districts and sub-districts. For every district, it establishes a registering office, a registrar's office. In every sub-district, it establishes sub-registrar's office. This is the hierarchy of the registration establishment. Every registrar and sub-registrar should keep the following books in the registration offices. They are Book 1, Book 2, Book 3, Book 4 and Book 5. Book 1 deals with register of non-testamentary documents related to immovable property. Only non-testamentary documents related to immovable property are recorded under book number 1. The record of reasons for refusal of registration are recorded under book number 2. The register of wills and authorities to adopt are recorded under book number 3. Other miscellaneous records are kept and recorded under the miscellaneous register, that is book number 4. The register of deposit of wills are recorded under book number 5. We need to note that all these books, book number 1, 2, 3 and 4, shall be kept in the offices of registrars as well as sub-registrars. In the offices of both the registrars as well as sub-registrars, book number 1, book number 2, book number 3 and book number 4 shall be maintained. But the register of deposit of wills, that is book number 5, shall be kept in the offices of only the registrars. Only in the offices of the registrars, the book number 5 is kept. The rest of the books are kept in the offices of both the registrars as well as sub-registrars. This is the rule. Coming to section 85, the unclaimed documents other than wills. Any registration office for a period exceeding 2 years may be destroyed. The registration officers are deemed to be the public servants within the meaning of IPC 1860 according to section 84. According to section 84, the proceedings under the Recession Act are deemed to be the judicial proceedings within the meaning of section 228 of Indian Penal Code 1860. This is about the registration establishment. Coming to the documents of which registration is compulsory. Section 17.1, 17.1a and 17.3 deal with documents of which registration is compulsory. Registration is compulsory as per these sections for the following instruments. They are gift of immovable property, non-testamentary instruments, gifts of immovable property, non-testamentary instruments of immovable property whose value is more than 100 rupees, which create, declare, assign, limit or extinguish in present or future any right, title or interest. The interest may be vested or contingent. Every gift of immovable property should compulsorily registerable. Registration is compulsory for gift of immovable property. Registration is compulsory for non-testamentary instruments of immovable property whose value is more than 100 rupees. Registration is compulsory for non-testamentary instruments which acknowledge the receipt and payment of any consideration which creates, declares, assigns or limits or extinguishes any right or title or interest. Here, registration is compulsory for leases of immovable property from year to year, from any term exceeding 1 year, or reserving any yearly rent. But leases of immovable property is compulsory in Andhra Pradesh. Registration of leases of immovable property is compulsory in Andhra Pradesh irrespective of whether they are executed for year to year or for any term exceeding 1 year or reserving a yearly rent. Registration is compulsory for non-testamentary instruments transferring or assigning any decree or order of the court in immovable property whose value is more than 100 rupees. If a decree is passed by the court or if an order is passed by the court related to the non-testamentary instruments which transfer or assign in immovable property whose value is more than 100 rupees, registration is compulsory. The contracts related to transfer of immovable property for consideration under section 53A of Transfer of Property Act. That section 53A of Transfer of Property Act deals with the part performance. One party pays the amount, the another party fails to transfer the property, or another property transfers the property, another party transfers the possession of the property, but the opposite party fails to pay the amount. Under such conditions, even such contracts related to transfer of immovable property for consideration under section 53A, that is part performance, registration is compulsory. For these instruments, registration is compulsory as under section 17.1, 17.1a and 17.3. Next, documents of which registration is not necessary. The registration is not necessary for certain instruments as under section 17(2). Any composite deed, shares in joint stock company, debentures in issued by a company, any endorsement upon or transfer of any debenture. Here composite deed, shares, debentures, endorsement of the debentures of a company, decree or order of the court other than those mentioned in the previous slide, any grant of immovable property by the government, any instruments of partition made by the revenue officer, any order granting a loan under Land Improvements Act, Land Improvements Loans Act, Agricultural Loans Act, Charitable Endowments Act, any endorsement on mortgage deed acknowledging the payment, any endorsement on mortgage deed, not mortgages, compulsory, registration is compulsory for mortgages, but endorsement on mortgage deed, registration is not necessary. Any certificate of sale of any property sold by public action by a civil or revenue officer, if any property is sold by a party in a public action which is conducted by a civil officer or revenue officer, for such instruments registration is not necessary. It is specified under section 17(2). Section 17(2). Next, the third category of documents. Documents of which registration is optional. Simply, we need to remember one thing, that is, the value of the immovable property is less than 100 rupees, registration is optional. Just by transfer of possession, that is delivery of possession, delivery of possession is enough. Registration is not necessary for any kind of transfer of immovable property whose value is less than 100 rupees. It is a general principle. According to section 18, instruments other than gifts and wills of immovable property value less than 100 rupees which create, declare, assign, limit or extinguish in present or future any right, title or interest, whether such interest is vested or contingent, registration is optional. Just remember this thing, value is less than 100 rupees. Instruments which acknowledge the receipt or payment of any consideration related to creation, declaration, assignment, limitation, extinguishment of any right, title or interest, registration is optional. Acknowledgement of the receipt or payment of such creation, declaration of right, title or interest is optional. Leases of immovable property for any time not exceeding 1 year. If the leases of immovable property for a time of 1 year or exceeding 1 year, registration is compulsory. But the leases of immovable property for any time not exceeding 1 year, the registration is optional. Instruments transferring or assigning any decree or order of the court in immovable property whose value is less than 100 rupees, registration is optional. Instruments other than wills of movable property which create, declare, assign, limit, extinguish any right, title or interest, registration is optional. Transfer of movable property, registration is optional. For wills, registration is optional, registration is not compulsory for wills. And the most important point we need to remember with regard to registration, with regard to the wills, registration of wills. Many of us have certain paradox that wills should be compulsorily registerable, but it is absolutely wrong. Registration of wills is optional and all other documents not required by section 17 to be registered. This is about category 3 of documents related to registration. Next, the documents of which registration is exempted. As under section 90 of Registration Act 1908, the following documents which are executed by the government or executed in favor of the government or exempted for registration. Here these 2 points need to be remembered. We need to remember these 2 points. The documents executed by the government. Government the government is executing certain documents. For such documents, registration is exempted. If you make any instrument, if you execute any instrument in favor of the government, then registration is exempted. Simply, we blindly remember one thing, that is, if any document executed by the government, registration is exempted. If any document executed in favor of the government, registration is exempted. Here, documents issued, received, attested by any government officer engaged in making a settlement of land revenue is exempted under section 90. The maps, plans issued, received, authorized by the government surveyor or equivalent government officer are exempted. The documents of village records which are filed periodically in any revenue office or exempt, registration is exempted. The sanads, inam title deeds, other documents purporting to be or evidence, grants or assignments by the government exempted from the registration as under section 90. Next, the persons to present documents for registration. It comes under part 2, that is procedure for registration. Section 32 and 33 of Registration Act 1908 deal with persons to present documents for registration. Who should present the documents at the time of registration in registering offices? The documents may be presented by person who is executing or claiming, or by his representative or assign, or by agent of his or by his agent or agent of his representative or assign. One can himself present the documents for registration, or he can present the documents by his representative or assign, or he can present the documents by agent of his representative or assignee, duly authorized by power of attorney, even if such documents, even by the power of attorney also, such documents can be presented in registering offices if such power of attorney is duly authorized by such executor. In AIR 1954 SC 316, it was held that the power of attorney with authentication specially for registration, the general power of attorney is not recognized. It has no legal value for registration, for presenting the documents for registration. General power of attorney has no legal value in order to present the documents for registration. Only the special power of attorney has legally enforceable to present the documents for registration. Special power of attorney duly authorized by the executor is legally recognized. The general power of attorney is not recognized by the law. The law of registration, that is Registration Act 1908. According to section 33, if the principal at the time of executing the power of attorney resides in India and where the Registration Act applies, it should make the special power of attorney before the registrar or sub-registrar and authenticated by the registrar or sub-registrar. It is the essential requirement in case of if the executor wants to uh, present the documents for registration with the help of the power of attorney. The power of attorney should be a special power of attorney to present the documents for registration. And if the executor resides in India and where the Registration Act applies, he should execute the special power of attorney before the registrar and sub-registrar, and it should be authenticated by the registrar or sub-registrar. This is the rule. The second one, if the executor resides in India but the Registration Act is not applicable in that area, he is residing in India but in that geographical area the Registration Act is not applicable, it does not apply. Under such circumstances, he should execute the special power of attorney before any magistrate, and it should be authenticated by any magistrate. If the executor resides outside India, he should execute the special power of attorney before notary public or any court or any judge, any magistrate, any Indian consul or any vice consul or representative of central government. It should be authenticated by any one of these persons. This is the law related to special power of attorney and the persons to present documents for registration as under section 32 and 33. Here the following persons are exempted from appearance at registration office as under section 38 of Registration Act 1908. The persons who are bodily informed, they are unable to move from the bed, who are bedridden, who are bodily informed, are exempted from appearance at registration offices. They can present the documents for registration by his representative or assign or agent of his representative or assign. The persons in jail under civil or criminal process are exempted. They can present the documents for registration by their representatives. The persons exempted by the law from personal appearance in the court. These three categories of persons are exempted from appearance at registration office. Next, under the procedure for registration, the compulsory affixing of photograph, etc. It is specified under section 32A of the Act. 32A of the Act. Section 32A speaks about compulsory affixing of photograph, etc. Here, the passport size photograph and fingerprints of the person, of every person presenting any document under 32 are required at the time of registration. Every person who is presenting any document under section 32 shall affix his passport size photograph and his fingerprints at the time of registration in registration offices. These are the essentials: passport size photograph and fingerprints. Every person presenting, every person. If a property is related to more than one person, if two or more members want to transfer such property to one or more than one persons, then the passport size photographs and fingerprints of every persons is required at the time of registration as under section 32A. If the document relates to sale, etc. of immovable property, then the passport size photograph and fingerprints of both the sellers and buyers is necessary as under section 32A. Here, before that is prior to 2001, these are not necessary. The passport size photograph and fingerprints are not necessary, but the new amendment was made, and section 32A was inserted by Act 48 of 2001 with effect from 24th September 2001. These are the new guidelines specified under section 32A of Registration Act in the process of registration. Next, enquiry before registration by the registering officer. It is specified under section 34. No document shall be registered without enquiry of the person executing the document before the registering officer within the time allowed for presentation. Without enquiry, no document shall be registered by the registering officer. Enquiry should be made by the registering officer at the time of registration. The registering officer should enquire whether or not such document was executed by those persons. He should enquire this thing. He should satisfy himself as to identity of the persons appearing. Hence, they need to show certain identity proofs like voter ID card, PAN card, driving license, or any other proof, any other card which is recognized for identity of the persons. The registrar should satisfy himself as to the identity of the persons appearing using certain documents, certain cards like PAN card, Aadhaar, or etc. The registering officer satisfy himself of the right of appearing persons or representative, assign or agent or POA. He should satisfy whether the person who is appearing for execution of the registration has right to appear. If he has no right to appear, then the registering officer may refuse to register such documents for registration. Nothing in section 34 applies to the copies of decrees or orders. For copies of decrees and orders, the enquiry is not necessary. Next, under urgent necessity or unavoidable accident, if such persons do not so appear, then the documents may be registered on payment of a fine not exceeding 10 times the amount of proper registration fee in addition to the fine within 4 months. Okay, this point will be explained in the further slides. Next, effect of admission and denial of execution is specified under section 34. Let us see what is the effect of admission of the persons who are appearing for execution of registration, and what is the effect of denial of the persons appearing for registration. Here, effect of admission. All the persons executing the document admit. If they admit the execution of such document, then the registering officer shall register the document. If in case of any person appearing by representative, assign or agent, if his representative, assign or agent admit the execution, then the registering officer shall register the document. If the person executing the document is dead, if his representative or assign admit the execution, then the registering officer shall register the document. Simply, if the person who is executing the document or his representative, assign or agent, if he is dead, his representative or assign admit the execution, the registering officer shall register the document. If any person by whom the document purports to be executed denies the execution, if the person denies the execution, then the registering officer refuses to register the document. If any person appears to the registering office to be a minor, idiot, or lunatic, if the person appearing for execution is a minor or idiot or lunatic, the registering officer shall refuse the registration of such document. This is the rule. If the person executing the document is dead, his legal representative or assign denies the execution, then the registering officer shall refuse to register the document. This is the rule specified under section 35 of the Act. Next, the time and place of registration. The time and place of registration. It is specified under different sections. According to section 23, a document other than will, in the further slides I will explain the concept of registration pertaining to wills. Here, as under section 23, a document other than will shall be presented within 4 months from date of its execution. For instance, a document is executed. Here, this is the execution related to sale of certain immovable property between Mr. A and B. Mr. A and B executed a deed of sale of immovable property on 1st January 2017. Here, they have executed the sale of immovable property, the deed related to sale of immovable property on 1st January 2017. They can present the document for registration within 31st April 2017. This is the rule. This is the rule according to section 23. Within 31st April 2017, the parties shall present such instruments for registration. According to section 23A, when a document is registered by a person not authorized to present for registration, here a document is registered by a person but he is not authorized to present for registration, the document can be presented again for re-registration by the authorized person if it is presented by an unauthorized person by mistake. Then the authorized person can represent the same document for re-registration. This is the provision specified under section 23A of Registration Act 1908. If documents executed by several persons at different times, if the documents are executed by several persons at different times, such document may be presented for registration and re-registration within 4 months from the date of each execution. Here, there are certain documents. Those documents are presented by several persons at several times, at different times. Such documents may be presented for registration and re-registration within 4 months is legally recognized. It is also acceptable according to section 24. Next, according to section 25, owing to urgent necessity or unavoidable accident, any document is not presented for registration after expiry of the period of time, the registrar, in case where the delay in presentation does not exceed 4 months, may direct the sub-registrar for registration on payment of fine not exceeding 10 times the amount of proper registration fee. Fine along with 10 times, not exceeding 10 times of the amount of registration fee. Such documents may be accepted for registration on the order of the registrar to the sub-registrar. If the registrar orders the sub-registrar with relation to registering a particular document which is not registered for a period not exceeding 4 months because of urgent necessity or unavoidable accident, on the order of the registrar, the sub-registrar may accept after paying the fine that is not exceeding 10 times the amount of proper registration fee along with along with the fine. Next, according to section 47, a registered document shall operate from the time from which it would have commenced to operate, not from the time of its registration. Here, this chart will help us to understand this concept. I will explain it later. According to section 48, registered documents related to property take effect against oral agreement but from date of registration. According to section 28, all documents related to immovable property shall be presented for registration in the office of sub-registrars within whose sub-district the whole or some portion of property is situated. This is related to place of registration. If the property is situated in Kadapa district, the documents related to immovable property shall be presented for registration in the office of sub-registrar of Kadapa. If the property is situated within Kadapa and Kurnool or Kadapa and Anantapur, under such circumstances, the documents related to immovable property shall be presented for registration either in Kadapa or in Anantapur. This is the rule. Next, according to section 30, registrar may, in his direction, may receive and register any document which might be registered by any sub-registrar subordinate to him. Here, the document for registration should be presented in sub-registrar's office in whose local jurisdiction our property is situated. This is the general rule. However, this is an exception. Section 30 is an exception. The registrar has certain discretion. With his own discretion, he may receive and register any document which might be registered by any sub-registrar subordinate to him. Here, sub-registrar 1, sub-registrar 2, sub-registrar 3. Here, this is sub-district 1, sub-district 2 and sub-district 3. In a district, there are 3 sub-districts. For each sub-district, there is one sub-registrar. The superior officer for these 3 subordinate sub-registrars is the registrar. The registrar is the superior officer for the 3 sub-registrars who are appointed by the state government for each sub-district in the district. Here, the registrar has the discretion to accept any document. He can accept, he can receive and register any document related to the property which is situated under the sub-district of sub-registrar 1. He has the discretion. He may receive and register the documents related to the property situated in the sub-registrar's jurisdiction. This is the rule. He has the discretion according to section 30. According to section 26, the documents executed out of India, if the documents are executed in a foreign country or in a geographical area where the Registration Act is not applicable, under such circumstances, such documents should be presented for registration within 4 months after its arrival in India. The document is executed in France on 1st February 2017. If the parties wants to register the execution of such document in India, it should be registered within 4 months after arrival into India. The parties who have executed the document on 1st February 2017 came to India on 2nd February 2017. They need to present the document for registration within 4 months, that is 2nd May 2017. After 2nd May 2017, the registrar may reject the registration. Here, using this chart, we can easily understand the concept related to the time and place of registration and the dominance of the time with related to registration. A document is executed on one date and registered in another date. Executed on 1st February 2016, but it is registered on 3rd March 2016. Then it is legally recognized, the execution date is legally recognized with regard to such a document. That is the 1st February 2016. That is date of execution. Any limitation starts from the date of execution but not from date of registration. This is related to this point. Next, a few parties orally agreed with relation to transfer of certain immovable property on a particular date, but they presented for registration on some other date. The document is registered on one date, they orally agreed on some other date. Here, under such circumstances, the date of registration is legally recognized. The limitation or etc. start from the date of registration, not from oral agreement date. The third circumstance, here there is a oral agreement and delivery of possession of the property in one date. Oral agreement plus delivery of possession of the property. They orally agreed to transfer certain property, and on the same date they delivered the possession of the property on one date, but it is registered on some other date. Under such circumstances, the date of agreement plus delivery of possession of the property is legally recognized. That date is legally recognized. The limitation starts from that date. The execution is really recognized from the date. This is the rule. Along with this, we need to understand one more principle with regard to the time and place of registration. That is, Mr. A executed a sale deed in favor of Mr. B on 1st April 2017 with regard to some property, that is property X. Mr. A again executed a sale deed in favor of C with regard to the same property, that is X, on 2nd May 2017. But Mr. A and C presented such instrument for registration on 3rd June 2017. But Mr. B presented the sale deed on for registration. He presented the sale deed for presentation for registration. He presented the sale deed for registration in the registering office, in the registrar office on 5th June 2017. This is the problem. Here, the instrument which was executed first, is legally recognized. It has more priority than the instrument executed later. The instrument which is executed prior to the subsequent execution, the subsequent instrument gets priority. The first executed instrument gets priority over the subsequently executed instrument. This is the rule. Hence, the instrument which is executed on 1st April 2017 has more priority, even though it is lately presented for registration. This rule we need to remember. The first thing which is represented, the first thing which was executed gets high priority over the subsequent executions. This is the rule held by the apex court in several cases. Next, the effect of non-registration of document required to be registered. A document should be compulsorily registered as under section 17. What will happen if such an instrument is not registered? This is explained under section 49 of the Act. Such document is not if a document of which registration is compulsory is not registered, then such document is not admissible in evidence. The court cannot accept such document as evidence in any kind of proceeding. It is specified under section 49. But there are certain exceptions for this rule. Such document may be received as evidence of a contract in a suit for specific performance. If a document is related to a contract in the suit of specific performance, then irrespective of its registration, such document is recognized as evidence in the court. And any collateral transaction not required to be effected by registration in the instrument, it simply means that here for certain part registration is compulsory, for rest of the part registration is not compulsory. However, the part related to certain matter of which registration is not compulsory may be accepted as evidence by the court in the proceedings. Registration of unstamped document. Here it deals with the relationship between the Indian Stamp Act 1899 and the Registration Act 1908. An unstamped instrument cannot be taken as evidence. The document should always sufficiently stamped. If the document or instrument is sufficiently stamped, then such instrument is recognized as evidence by any court. If the document which is not sufficiently stamped, presented after paying the penalty under Indian Stamp Act, that is after sufficiently stamped along with the penalty, then such instrument becomes good presentation and shall be accepted as evidence. Unstamped instruments cannot be treated as evidence. If the unstamped or the instruments which are not sufficiently stamped presented after paying the penalty under Indian Stamp Act, then they become good presentation and they shall be accepted as evidence in the court proceedings. This is the rule specified under section 49 of the Act, the Registration Act 1908. Next, this part is related to registration of wills. According to section 27, wills may be presented or deposited for registration at any time. Here, registration of wills is optional. Registrations may be get registered. Registration is optional with regard to the wills, but the wills may be presented or deposited for registration at any time according to section 27. But with regard to other instruments specified under section 17, the document should be presented or deposited for registration within 4 months. Within 4 months of their execution, not exceeding 4 months from their execution. But this rule is not applicable to wills. Wills may be presented or deposited for registration at any time. There is no time limit for presenting for registration of the wills. Next, persons entitled to present the wills to any registrar or sub-registrar. Generally, the wills are presented to the registrar. Section 40 and 41 deals with the persons entitled to present the wills to any registrar. Section 44 deals with the persons entitled to withdraw the wills from the registrars or sub-registrars. It is explained in this part. Here, the wills may be presented by the testator of certain immovable property or the donor of the immovable property in case of gift. After the testator or donor's death, any person claiming as executor or otherwise under the will, such wills may be withdrawn by any person claiming as executor or otherwise under the will, or such wills may be withdrawn by the testator himself. If the testator wants to make certain changes, if he want to make the will in favor of some other party, he may withdraw the will which was already presented and deposited with the registrar in the registering office. This is the rule. Next, the deposit of wills with any registrar is specified under section 42. The wills should be deposited with any registrar, not to the sub-registrar, to any registrar by the testator personally, by his authorized agent, in a sealed cover. Such wills should be always kept in the sealed cover, superscribed with the name of the testator. He should execute the will. He should keep the will in a sealed cover, and in that sealed cover, the sealed cover should comprises of a superscript. It should be superscribed the name of the testator, Mr. XYZ's will, with the statement of nature of the document. This is related to presentation and deposit of wills to any registrar, not sub-registrar, registrar. Next, procedure for deposit of wills is specified under section 43. On receiving such cover, the registrar, on satisfaction, if he satisfied the identity of the testator or his agent, on satisfaction, the registrar keeps such sealed cover in book number 5. Book number 5. Here in the initial slides, we discussed that book number 5 should be always maintained by the registrar, not by the sub-registrar. In book number 5, the wills shall be deposited. The deposit of wills shall be maintained and recorded under book number 5 only in the registrar's office, not in sub-registrar's office. The registrar, on satisfaction, keeps such sealed cover in book number 5 with superscription related to the name and nature of the document, the name of the testator and nature of the document, the year, month, day and hour of such presentation, year when it was presented, along with the time, day, year, month and time, a note on the receipt if it is necessary, names of the attestors who testify the identity of the testator, at least 2 attestors, names of the attestors who are testifying the identity of the testator. Next, his seal, the registrar's seal. The registrar shall place and retain the sealed cover in fireproof box. He always place that sealed cover. After keeping all these details, he retains the sealed cover in the fireproof box. Next, proceedings on death of the depositor of wills. What will happen if the depositor of will dies? If he dies, what will happen? If the depositor of the will dies, what will happen? It is specified under section 45 of the Act 1908. On death of the testator, an application be made to the registrar. An application to be made to the registrar. If the registrar satisfied that the testator is dead, hence the person should produce the death certificate of the testator. After observing the death certificate of the testator, upon satisfaction, the registrar, in applicant's presence and with applicant's expense, opens such cover, such sealed cover, and cause the contents thereof to be into book number 2. He opens the sealed cover and he records the contents of that will in book number 3 in his registrar office. When such copy has been made, the registrar shall redeposit the original will. Next, reasons for refusal of registration is specified under sections 19 to 22. Read with section 71 of Registration Act. Here there are 4 reasons, there are 4 grounds for refusal of registration by the registering officer. The first reason is documents in the language not understood by the registering officer. If the documents are in a language that is not understood by the registering officer, or such language is not commonly used in his district, under such circumstances, under such reason, the registering officer may refuse to registration. It is specified under section 19. If the documents containing interlineations, certain corrections, blanks, certain columns are not duly filled by the executors. There are certain erasers, certain things are removed, striked, a few things are erased with the help of eraser or blade. Certain alterations are made to the document. Under such circumstances, the registering officer may refuse for registration. There is an exception for this rule, that is, if the persons who are executing such document attest with affixing their signatures where the interlineations or erasures or alterations are made, then those documents shall be accepted for registrations. If there is no signature, by the executors, then according to section 20, the registering officer may refuse to register such document. The third reason is, if there is no description of property and maps or plans, then he can refuse to registration. There should be a clear description of the property. The executor should mention the survey number, the boundaries, north, south, east, west, east. The boundaries, they need to describe that their property is located here, Mr. X property is located on east side, there is a road in the north side, there are some fields in south side, there is a bungalow of Mr. Y in west side. Like this, they need to describe the property. They need to produce the map related to the property. In case of a building, they need to produce the plans, approvals by the appropriate authorities. Without the description of the property, maps, plans or other documents, the registering officer cannot accept for registration. He may reject the registration if there is no description of property and maps or plans as under section 21, 22 and 22. The fourth reason is, if the property is not situated within the registering officer's sub-district, the property, Mr. A has certain property in Adilabad district. If Mr. A presents the instruments for registration in Nizamabad district, then the registering officer of Nizamabad district will refuse to registration as under section 71. We need to remember this one, that is, property should be situated within the registering officer's sub-district. If your property is situated in the jurisdiction of a particular sub-registrars, you should produce such document to the registering officer of such sub-registrar. You need to produce such document in such sub-registrar office. This is the rule specified under section 71. The reasons for refusal should be recorded in book number 2. We have already discussed in the previous slides. Understand the reasons for refusal of registration should be recorded in book number 2 and shall endorse the words registration refused. The sub-registrar or registrar should endorse the words registration refused on such documents. It is specified under section 74. We need to remember one thing, that is, if the registering officer is refusing the registration because of the first reason, second reason, or third reason, he need to record the reasons for refusal in book number 2. If the reason is, if he refuses the registration on reason number 4, recording of the reasons for refusal in book number 2 is not necessary. If he refuses the registration because of these 3 reasons, he need to record those reasons in book number 2. If he refuses the registration because of the 4th reason, recording the reasons for refusal in book number 2 is not necessary. Next, on application, the registering officer shall give a copy of reasons to the so recorded in book number 2 to the parties without payment and unnecessary delay on application. If the executors files an application to the registering officer, then the registering officer shall give a copy of reasons for refusal without receiving any payment and without unnecessary delay. Next, appeals in case of dissatisfaction, in case of refusal for registration by the registering officers. According to section 72, if the sub-registrar refuses to register the document, then the executors shall go for an appeal within 30 days to the registrar as under section 72. If the sub-registrar refuses to register, then within 30 days they can go for an appeal to the registrar. Then the registrar, after scrutiny, after observing all the documents, if he satisfies himself that all the documents are sufficient for registration, then he orders the sub-registrar to register the same. After receiving the orders from the registrar, within 30 days, the executors need to represent the same documents to the sub-registrar for registration. This is the rule specified under section 72. If the sub-registrar refused to accept, the registrar refused to register the document, then an appeal is filed to the registrar. Sub-registrar rejected or he rejected the registration, then an appeal is filed within 30 days to the registrar for registration. Again, the registrar refused. Again, if the registrar refused the registration, under such circumstances, the registrar should record the reasons for refusal in book number 2 as the same way. Then within 30 days, the parties may file a suit in the civil court. There is no appeal lies from the order of the registrar under section 72 or 76. If the registrar rejects the instruments for registration, then there is no second appeal. The parties need to file an application in the civil court The civil court for registration. This is the procedure with related to appeals. We need to remember one thing, that is, if the decree is passed by the court in favor of the party, the civil court passed a decree in favor of the party, then the party should present the document for registration within 30 days of passing of such orders. Here 30 days for appeal, here from sub-registrar to registrar 30 days appeal, from registrar to suit in a civil court 30 days, within 30 days. 30 days is the limitation for appeal, 30 days here, 30 days is the limitation for the suit. Here after the suit is passed in favor of the party, they need to present within 30 days for registration. Here in first appeal, if the registrar passed a decree for registration against the refusal of registration by sub-registrar, the parties need to present for registration within 30 days. Next, penalties for non-registration, etc. According to section 81, if the documents are incorrectly endorsed, copied, translated, then there will be an imprisonment up to 7 years, or with fine, or with both. This is the punishment in case of incorrect endorsement, copy, translation, or registration of the documents. It is specified under section 81. In case of intentionally making false statements, delivering false copies, false translations, and false personation and abatement, the punishment is up to 7 years with fine or with both. It is specified under section 82. That is, next, registering officer may commence the prosecutions. The registering officer may commence the prosecution as under section 83, triable by the officers not less than those of magistrate of second class. Next, the miscellaneous provisions. Certificate of registration. How should be the certificate of registration? What are the contents of the certificate of registration? It is mentioned under section 60 of the Registration Act. The registering officer shall endorse a certificate containing the word registered on the document. He endorses that registered on the document along with registration number, page number in the book where he registered such document. In book, if he recorded such particulars in book number 1, 2, 3, 4 or 5, the number, the page number of such book should be recorded in the certificate of registration. The signature of the registering officer, the seal, his seal, and the date of registration. These are the contents of the certificate of registration as under section 60. Endorsements and certificates to be copied and documents returned to the persons who presented the same for the registration. Endorsements and certificates to be copied and documents returned to the person who presented the same for registration. Endorsements, copies, documents are returned to the parties who presented for the registration. On registration of the document relates to immovable property, the registrar shall forward a memorandum of such document to each sub-registrar. We have discussed in the previous slides that if certain property is located in two districts or in two sub districts. If the party registered his property in sub district 1, then such sub registrar sends a copy of such registration to the another sub district in which certain portion of the such property is situated. Next, copies of certain orders, certificates and instruments to be sent to the registering officers. Every court shall send a copy of certificate of sale of immovable property under CPC to the registering officer within local limits of whose jurisdiction the whole or any part of land is situated. This rule is prescribed under section 89 in order to protect the rights of the decree holder. In a civil suit, if a decree is passed in favor of a party, such party is generally treated as the decree holder. But there are certain chances for the judgment debtor. Judgment debtor is the person against whom a decree is passed. There are certain chances for the judgment debtor to fraudulently register such instrument in the registering officer. In order to avoid such complexity, every court should send a copy of certificate of sale of immovable property under the Code of Civil Procedure to the registering officer. A copy is used by the registering officer as a reference if the party other than the decree holder comes and presents certain instruments for registration in the registering officer, the registering officer may refuse to register such document based upon the certificate of sale of immovable property issued by the court in favor of the decree holder. It gives certain protection. Next, every tribunal send a copy of its certificate to the registering officer if it passes any orders in favor of a particular party. Such certificate should be sent by the tribunal to the registering officer. Then every officer shall send a copy of his order granting loan under the legislations of land improvements and agricultural loans under Land Improvements Act, under Agriculturist Loans Act. If any person gets some loan from the bank, such certificate related to the property of the person who got the loan from the bank should be sent to the registering officer. The officer who is granting the loan for agricultural purpose, for land improvement purpose, for other legislations notified by the governments. Such documents are sent by such officers to the registering officer for reference. Every revenue officer shall send granting a copy of certificate of sale of immovable property sold by the public auction. If certain property is sold by the revenue officer or other government officer to some other person in public auction, such certificate should be sent by the revenue officer to the registering officer. Then based on the certificates of the court, tribunal, officers, or revenue officers, the registering officer may accept for registration, may reject for the registration. The registering officer shall file the copy in book number 1. Friends, thank you for watching my video. For latest updates on various law topics, don't forget to subscribe to my YouTube channel, Subhan's Legal World. Thank you and goodbye.